Jonathan Roumie versus Justice Amy Coney Barrett. The Supreme Court chamber fell into stunned silence. What had just happened was unlike anything seen in the modern history of American jurisprudence. Justice Amy Coney Barrett, one of the most powerful voices on the nation's highest court, had just attempted to cut off Jonathan Roumie mid-sentence during oral arguments. What Roumie delivered in response left everyone in that marble-pillared room breathless. The tension had been building for months, but no one, not the seasoned justices, not the packed gallery, not even the veteran legal correspondents, was prepared for what would unfold. In the span of 30 seconds, an actor known for playing Jesus on television would challenge the very soul of the Supreme Court. And Justice Barrett's reaction would send a shockwave through Washington, D.C. The chamber's atmosphere was electric with anticipation. Spectators who had lined up since dawn sensed they were about to witness something unforgettable. Legal scholars in the gallery exchanged hushed, anxious glances, while veteran Supreme Court reporters tightened their grips on notepads and phones, bracing for what could be the most consequential moment of their careers. Before we dive into this explosive confrontation that's already dominating headlines and lighting up the internet, hit that subscribe button and ring the notification bell. This story has everything: power, tradition, moral reckoning, and two towering figures facing off in the highest court of the land. But this wasn't a routine legal disagreement. This was a clash between two visions of America. And what Jonathan Roumie said next would either define his legacy or end it. Justice Amy Coney Barrett, 53, appointed by President Donald Trump in 2020, is a legal powerhouse with a staunchly originalist philosophy. Known for her precise legal reasoning and calm demeanor, she's built a reputation on restraint, tradition, and intellectual discipline. A mother of 7 and former professor at Notre Dame Law School, Barrett has become an icon for conservative constitutionalists. From clerking for Justice Antonin Scalia to ascending rapidly through the federal judiciary, Barrett's journey has been defined by rigorous adherence to the text of the law. She believes deeply in maintaining institutional dignity, and she rarely tolerates deviations from formality, especially in the solemn chambers of the court. But today, she wasn't facing a conventional advocate. Today, she was facing Jonathan Roumie. Known to millions as the actor portraying Jesus Christ in The Chosen, Roumie is more than a screen presence. He's become a voice for moral integrity in public life, an artist who speaks as a citizen, a man of conscience who brings spiritual gravitas to secular debates. He's addressed crowds at the March for Life. He's been invited to the White House prayer breakfast. And now he stood before the 9 justices of the Supreme Court, not as a lawyer, but as a representative of something deeper, the conscience of ordinary Americans. Roumie wasn't there by accident. He had been granted a rare invitation to deliver oral arguments in Hendersonville, Texas, a landmark voting rights case that could redefine how congressional districts are drawn across the nation. He was not a plaintiff, not a lawyer, but a moral amicus, permitted to speak as the voice of millions who felt unheard in the democratic process. Many traditionalists had scoffed. What was an actor doing at the Supreme Court lectern? But Roumie had spent months preparing. He consulted with constitutional scholars, civil rights attorneys, and theologians. He poured over decades of redistricting cases and crafted his address like a script. But this one was real. He wasn't performing, he was intervening. Justice Barrett, who had voiced concerns in closed sessions about blurring the line between law and sentiment, was particularly wary. To her, inviting Roumie to speak at all was a dangerous precedent, one that risked turning the judiciary into a stage. The chamber was filled to capacity. Law students, clergy, activists, and everyday Americans sat shoulder to shoulder. The mood was reverent. Every eye watched as Roumie entered, not in a standard-issue charcoal gray suit, but in a clean navy one with a dark tie, understated and elegant. His presence wasn't theatrical. It was composed, almost priestly. Justice Barrett took her seat, serene as ever. But to those who knew her closely, her posture was stiffer than usual. She was prepared for a moral appeal, but not for what was about to hit her. You can't dismiss the people. When Jonathan Roumie stepped into the chamber, heads turned. Unlike the typical gray-suited lawyers who usually stood before the justices, Roumie wore a deep navy suit, elegant but modest, the kind of suit that spoke without shouting. There was no flash, no theatricality, just presence. And his presence shifted the energy in the room. Chief Justice Roberts gavelled the court to order. The formalities began. But from the instant Roumie rose to speak, it became clear this would not be an ordinary day in the Supreme Court. "Your honors," Roumie began, his voice calm yet resolute, the tone of someone who had stood before thousands, not to argue but to move hearts. "I come before you not as a lawyer nor as a politician, but as a citizen, a man who has walked alongside people whose voices often go unheard in chambers like this." Justice Thomas leaned forward, unusual for him. Justice Alito's pen paused mid-sentence. Even Justice Amy Coney Barrett, usually intent on her notes, looked up with subtle interest, but her jaw also tensed just slightly. Those who had followed her career closely recognized the signal. Disagreement, and it was only just beginning. As Roumie calmly outlined the implications of the case, Henderson versus Texas, the questions began to come. Fast, precise, piercing. Justice Kavanaugh challenged his understanding of constitutional precedent. Justice Gorsuch probed the limits of his grasp on federalism. But Roumie stood his ground. He cited legal history, he quoted directly from landmark rulings. But more than that, he spoke with moral clarity, less like a man trying to win a legal argument, more like a citizen trying to awaken a conscience. This wasn't an actor playing expert. This was a man who had done the work and who had earned the right to be heard. "Mr. Roumie," Justice Alito finally interjected, his tone sharp, "are you suggesting this court discard decades of legal precedent to accommodate popular sentiment?" A murmur rippled through the gallery. This was the moment that could break him. Roumie didn't flinch. He paused, then smiled. Not out of arrogance, but the steady smile of someone ready. "Justice Alito," he said respectfully, "I'm not asking this court to discard precedent. I'm asking it to remember its purpose. Equal justice under law is not a political preference. It's a constitutional promise, and it's one that millions feel has been quietly broken." A few in the gallery gasped. One could almost hear hearts beating faster. Roumie pressed on. He wove in the stories he had gathered, not statistics, but names, faces. Americans disenfranchised by gerrymandering. Communities split in half by maps drawn to silence their vote. Voters who had waited 8 hours in line, only to be told they were in the wrong precinct. "Your honors," he said, voice deepening with conviction. "This case isn't a sterile exercise in text and footnotes. It is about real people losing their voice in a democracy that promised to protect it." That's when Justice Barrett struck. "Mr. Roumie," she said, her tone suddenly cold and clipped, "this court is not a platform for political storytelling. We are here to interpret law, not to entertain personal anecdotes." The room froze. Even the stenographer looked up. Justice Barrett continued, "Your role here is to offer legal reasoning grounded in constitutional interpretation, not to deliver speeches." The rebuke hit like a thunderclap. It wasn't just sharp, it was public. And from one of the court's most prominent voices, Roumie stood silently for a moment. Then he smiled again. Not the kind of smile one gives in surrender, but the kind that signals, "Now we're getting to the truth." "With the deepest respect, Justice Barrett," he began, his voice steady and compassionate, "I must disagree." The entire chamber inhaled sharply. Had a civilian guest speaker just told a sitting Supreme Court justice that she was wrong? Roumie stepped forward slightly, his shoulders straightening, his hands resting firmly on the podium. "You say personal stories have no place here," he continued, "but weren't personal stories at the heart of this court's most moral decisions? Wasn't it Linda Brown's experience that led to Brown versus Board of Education? Wasn't it the story of Clarence Gideon, a poor man denied a lawyer, that gave us the right to counsel?" Justice Barrett's face was still, her knuckles whitened slightly around her pen. Roumie continued, now with quiet force. "Justice Barrett, during your own confirmation hearings, you spoke about your family, your faith, your children, how those experiences would shape your perspective on the bench. Were those stories irrelevant to your fitness for this court? Or do we only value personal experience when it's our own?" The courtroom was silent. The air hung thick with tension. Chief Justice Roberts didn't speak. He didn't move. Even he seemed suspended by the gravity of what was unfolding. But Roumie wasn't done. "I do not stand here with a law degree from Yale or Harvard," he said, gesturing gently toward the public gallery. "And neither do most Americans. But they know injustice when they see it. They feel it in their bones when their vote doesn't count." He looked directly at Barrett now. "And when you dismiss their stories as irrelevant to the Constitution, you're not just silencing me, you're silencing them." Justice Barrett leaned forward, about to speak, but Roumie raised a respectful hand. "If this court believes that lived experience has no role in constitutional interpretation," he said softly, "then perhaps it is the court, not the people, that has lost its way." The words struck like a slow-building storm, quiet at first, then deafening. A man who had never served in Congress, never argued a case in court, never held elected office. And yet, in that moment, Jonathan Roumie was speaking for a nation. The Constitution belongs to the people. "Mr. Roumie," Chief Justice Roberts said, his tone firm but not unkind, "please confine your remarks to the legal issues before the court." But the moment was already irreversible. In less than 2 minutes, Jonathan Roumie had transformed what began as a public rebuke into a seismic challenge to how the Supreme Court understands its own role. And Justice Amy Coney Barrett looked, visibly, for the first time in her tenure, caught off guard. What happened next would be studied in law schools and replayed in headlines for years to come. Justice Barrett, a formidable judicial thinker and staunch defender of constitutional originalism, now found herself in uncharted territory, not under attack on technical legal grounds, but facing a direct and public confrontation of her judicial philosophy on moral grounds. She leaned back in her chair, her eyes narrowing, measuring Roumie with the intensity of someone who rarely encounters dissent that isn't carefully filtered through clerks or legal briefs. Her voice, when she finally spoke, was measured and heavy with authority. "Mr. Roumie, are you suggesting that this court's commitment to constitutional law should be subordinated to public sentiment?" It was a trap laid with surgical precision. If Roumie said yes, he would be endorsing mob rule. If he said no, he'd be backing away from everything he had just declared. But Jonathan Roumie had stood on many stages before this one, and he did not come to back down. "Justice Barrett," he replied, his voice calm but unwavering, "I'm suggesting that constitutional law, when divorced from its impact on the people it claims to protect, ceases to be law and becomes theory, academic, abstract, and dangerously indifferent." A ripple passed through the chamber. Even Justice Thomas, who had remained silent the entire session, looked up. Roumie pressed forward, his voice building not in volume but in force of meaning. "This court has the power to interpret the Constitution, but the Constitution," he said, gesturing toward the seal above the bench, "belongs to the people." He turned and pointed gently toward the crowd in the gallery. "When this court makes decisions that systematically exclude certain voices from democracy, it is not protecting the Constitution, it is betraying it." Silence. Roumie stepped back for a beat, then turned his eyes toward the portrait of Chief Justice John Marshall, looming high on the chamber wall. Marshall established judicial review not to enshrine an aristocracy of legal scholars, he said, but to ensure that the Constitution remained a living document, one that served all Americans, not just those with the education and pedigree to navigate complex jurisprudence. Justice Barrett's face flushed ever so slightly. Anger? Embarrassment? No one could quite tell. But Roumie wasn't finished. "Justice Barrett," he continued more softly, "you've spoken eloquently, often, about how your experience as a mother, a woman of faith, and a scholar from the Midwest shapes how you see the law. You've said diversity of experience strengthens this court." She blinked, startled by the pivot, even moved, perhaps. "I agree," Roumie continued, "but if your experience matters to your judgment, why doesn't the experience of those living under your judgment matter just as much?" The brilliance of the argument wasn't just in its logic, it was in its precision. Roumie had turned Barrett's own judicial philosophy back on itself. The other justices were paying attention now, intently. Even the conservative bloc, Alito, Gorsuch, Kavanaugh, sat with eyes fixed forward. The room was thick with the tension of unspoken reckoning. Before Barrett could respond, Roumie stepped forward again, reaching into the inside pocket of his suit. He pulled out a small card and held it gently in his hand. "I want to read you something," that he said. He unfolded the card slowly, reverently. "This is the oath I took just a few years ago when I addressed thousands on the National Mall as a citizen and speaker for those who felt voiceless." His voice lowered, deep and slow. "I do solemnly swear that I will support and defend the Constitution of the United States against all enemies, foreign and domestic." He looked up. "That same Constitution that gives you the authority to interpret the law gives every citizen the right to be heard by those in power." Then he locked eyes with Barrett. "So when you tell me that their stories, the people's stories, don't matter in constitutional interpretation, you're not just dismissing me, you're dismissing them." The words didn't ring out like thunder. They fell like a final verdict. Justice Kavanaugh cleared his throat, attempting to break the spell. "Mr. Roumie," he said, "perhaps we can return to the specific legal claims in the case." But Roumie turned to him. not defiant, but unshaken. Justice Kavanaugh, the legal question is whether the American people have equal voice in their democracy. He paused. The constitutional question is whether this court will protect that voice or ignore it. He took one last breath. And the human question, which I would argue is inseparable from the others, is whether someone in East Austin or South Chicago has the same political power as someone in suburban Fairfax. Justice Barrett had remained silent, but now she leaned forward. When she spoke again, her tone had shifted. The edge was gone. What remained was something quieter and more uncertain. "Mr. Roumie," she asked, "what exactly are you asking this court to do?" It was the moment he had been waiting for. The shift from defense to offense. The shift from being questioned to leading the questions. Roumie stepped to the center of the podium, no longer speaking just to one justice, but to the institution itself. "I'm asking this court to remember that every constitutional principle, every amendment, every clause, every comma exists to serve real people living real lives." He paused. The air was heavy now, sacred almost. "I'm asking you to remember that when you weaken protections, when you narrow rights, you are not just writing legal doctrine. You are deciding who gets to participate in American democracy." He gestured again toward the gallery. "I'm asking you to recognize that equal protection under the law isn't a theory, it's a reality, or it's a lie." Then Roumie did something that would be replayed for weeks to come. He looked at Justice Barrett, not as a petitioner, not as a critic, but as one servant of the public to another. "You've spent your career opening doors for people who once had none. You've shown that excellence comes in many forms, that conviction and motherhood and scholarship and faith all have a place on the bench." She blinked, her face softened. "All I'm asking," Roumie said, "is that you apply that same principle to the people whose cases come before you. They may not hold law degrees, but they carry wisdom. They may not write law review articles, but they live with the consequences of your rulings." The chamber held its breath. This was no longer a courtroom, it was a reckoning, a court that serves the people. "They may not cite precedent," Roumie said, the silence thick around him, "but they know justice when they feel it, and they deserve to have their voices heard, not only in elections, but in the courtrooms where their futures are decided." Justice Amy Coney Barrett sat in stillness, her face unreadable, but her silence spoke volumes. She was wrestling with something, not the content of a legal brief, but a challenge to the very way she had framed her judicial role. The entire chamber waited, then finally she spoke. Her voice was no longer sharp or guarded. "Mr. Roumie," she said slowly, "you've given this court much to consider." It wasn't an admission of defeat, but it wasn't a dismissal either. And in this courtroom, that was seismic. A sitting Supreme Court justice, renowned for her commitment to judicial restraint, had just publicly signaled that she may have been wrong, or at least incomplete, in her understanding of how the law connects to the lives of those it governs. Barrett continued, her tone softened. "Perhaps the question isn't whether personal stories belong in constitutional interpretation, but how we balance those experiences with legal principles." The ripple effect was instant. In the press box, reporters were already hammering away at phones and laptops. Legal scholars in the gallery sat stunned. Even Chief Justice Roberts turned slightly in his chair, as if to reground himself in the shifting energy of the court. But Roumie wasn't satisfied with a symbolic concession. He stepped forward once more. "With all due respect, Justice Barrett," he said with calm gravity, "that balance isn't achieved by filtering out human voices. It's achieved by inviting more of them into this space." And he said the words that would define the confrontation, an echo across social media, classrooms, and editorial pages nationwide. "This court's legitimacy doesn't come from being removed from the people. It comes from serving them, and you can't serve people you refuse to hear." For several long seconds, no one spoke. Justice Barrett looked at Roumie as if seeing him for the first time, not as an outsider, not as a performer, but as a fellow public servant delivering an uncomfortable truth. Then, finally, she nodded. "Point taken," she said. "Mr. Roumie, please continue." What followed was no longer just a legal presentation. It was a moment of moral transformation. As Roumie wrapped up his address and stepped away from the podium, the chamber buzzed. Not with chatter, but with an energy few had ever felt in that historic hall. Law professors were already texting their students. Legal reporters whispered to producers. Even the justices themselves exchanged glances, as if something had just shifted. Justice Barrett remained on the bench, composed, But something in her demeanor had changed. Where her morning questions had been sharp and doctrinaire, her afternoon remarks were thoughtful, even inquisitive. Her voice now carried a note of humility, of reflection. By the time Chief Justice Roberts adjourned the session, the usual stately exit dissolved into something closer to controlled chaos. Reporters sprinted down the courthouse steps. Cable anchors went live. Twitter, especially legal Twitter, erupted. Within minutes, the hashtag Roumie vs. Barrett was trending nationwide. Professor Lawrence Tribe posted, "In 4 decades watching the court, I've never seen anything like this." Jonathan Roumie just delivered a moral masterclass in constitutional conscience, a democratic awakening. Professor Randy Barnett wrote the next day, "Jonathan Roumie reminded the court that its legitimacy depends on the consent of the governed. That's not a threat to judicial independence. That's a defense of constitutional democracy." And that single line summed up the mood sweeping the nation. The exchange had cracked open a long closed door, a door into the soul of the court, and into a national conversation about what it means for institutions to serve the people who empower them. Even in subsequent sessions, observers noticed a subtle but undeniable change in Justice Barrett. She asked more questions about real-world consequences. Her tone grew more exploratory, less rigid. It wasn't a reversal of ideology. It was humility, a willingness to listen. Meanwhile, Jonathan Roumie used his rapidly expanding platform for something rare: civic revival. He didn't grandstand, he educated. He called for deeper civic education. He encouraged young people to study the Constitution, not as lawyers, but as citizens. He asked Americans to re-engage with their institutions, not with blind loyalty, but with informed courage. Because what had just happened in that courtroom wasn't just a dramatic moment in legal history, it was a symbolic turning point, a shift in how we think about judicial authority, democratic representation, and the sacred relationship between legal expertise and popular sovereignty. By refusing to be silenced, Jonathan Roumie had shown that respect for institutions doesn't require passive deference. And by acknowledging Roumie's challenge, Justice Barrett had shown that judicial wisdom includes the courage to learn from those outside the marble halls. Together, they modeled something this country desperately needed: a way for people to disagree without destruction, to question without contempt, to hold power accountable while still holding it together. In an era defined by division, distrust, and noise, their exchange gave the nation something far more powerful: a glimpse of democratic maturity. The impact of those 10 minutes will echo for decades. Law schools have already added the moment to their constitutional law curricula. Debates rage in classrooms, newsrooms, and dining rooms. Was Roumie out of line? Or did he do precisely what every citizen should do when they believe authority is straying from justice? Some say he disrespected the court. Others believe he reminded it why it exists. Either way, one thing is clear: this was not the end of a story. It was the beginning of a reckoning. So, what do you think? Did Jonathan Roumie go too far in challenging Justice Barrett? Or did he do exactly what moral leaders must do in a free republic? Let us know in the comments below. And if this story resonated with you, don't forget to subscribe and ring the bell.